Ladies and gentlemen, I'm Shidarta from the Business Law Department of the Faculty of Humanities of Jakarta-based BINUS University. And along with me is Imelda Martinelli from the Faculty of Law of Tarumanagara University. We will present the result of our research on the legal politics of gender inequality in determining legal capability in Indonesian legislation. If we talk about gender inequality, actually this has happened for a long time in history. In the contemporary era, we also ask how to put such an interpretation of gender equality in our legislation. After 75 years of Indonesian independence, is this particular dimension still lingering in our positive law? The key factor in answering such question lies in legal politics. This research essentially wants to build several theses that can answer the main question. In what areas of law does gender inequality related to legal capability usually occur? And can this inequality be strengthened or weakened? In the midst of the COVID-19 pandemic, the problem of legal politics in overcoming the crisis is also often associated with the phenomenon of gender inequality. Unfortunately, many statements regarding this association are not based on clear arguments. This is because not all areas of the law are related to gender issues. This study uses a method that relies on primary legal materials by analyzing statutory text. One critical issue in our legislation related to our research is legal capability. For that purpose, we can look at legislation mentioning the concept of legal capability. Legal capability usually becomes complex when dealing with private law. Private law in Indonesia is regulated in a variety of complex legal sources. There are two criteria in determining legal politics related to the issue of legal competence. The first criterion is based on qualitative measure, while the second criterion is quantitative. One of the distinguishing criteria is the nature of the legal substance regulated in the legislation. In this case, there are also two categories. First, a neutral and non-neutral legal substance. A neutral legal substance exists when the material of that legislation do not come into contact with primordial aspects. On the other hand, it is non-neutral if the substance is strongly charged with primordial elements. We can consider some examples of legislation as seen on the screen. First of all is the Civil Code. Article 330 states, minors are persons who have not achieved the full age of 21 and have not entered into marriage before. If the marriage terminates before they attain the age of 21, the spouses do not return to the minority status. This chapter determines when a person in the minor category become major. This criterion has the same meaning as a person status from incapability to capability in law. But please read Article 330 of this Civil Code appropriately, since it has something to do with the status of married woman. Let us take a look at the politics of law in the marriage law. The standard of 19 years old is the most recent age benchmark. As previously, the minimum age for marriage was differentiated between men and women. Our legal politics in the marriage law are also unclear in addressing this violation of the provision regarding the minimum age for marriage. This influence of religious law and customary law is still very strong, so that the minimum age requirement in the legislation is likely a regulatory provision rather than a compelling one. The age of children has many various standards. In general, the age of children is below 18 years. This standard can be observed in the juvenile law in the Manpower Act. However, the law on population administration laws is different, namely 17 years. The problem is that if a child marries under the age of 21, according to the Civil Code, we can categorize the marriage as a child marriage. Meanwhile, according to marriage law, it is not a child marriage. Now, let's compare the legal politics in the law of marriage with that of inheritance. In Western inheritance law, the capability to act is very advanced by no longer looking at the gender aspect, but at the child's interest. As stated in Article 2 of the Civil Code, a fetus in a woman's womb can be regarded as a born child if the fetus interests are required. If the child dies at the time of delivery, she will be deemed as never exists. Let us take another example of a legal area. We can see in law number 11 of 2012 concerning the juvenile justice system. In this law, we can find the term children in conflict with the law. The term is defined as a child who has reached the age of 12 years, but has not yet reached the age of 18 years, who is suspected of having committed of a criminal act. The ability to be responsible under criminal law is a child between the age of 12 and 18. Under the age of 12, someone has a legally incapable status. Here, legal capability is determined very quantitatively. That is only based on age. For law and population administration, has another standard for the legal capability. It requires any resident of Indonesian citizen and foreigners as permanent resident who have reached 17 years or have married or once have married, they should obtain ID card. In the Manpower Act, the age standard for 18 years is also the only benchmark. That is, someone is said to be child labor if he is under 18 years of age, regardless that the child is married. Finally, let's look at the Information and Electronic Transaction Act. This law is closely linked to technology and in itself is in a natural domain. In this law, there is no mention of the age limit for a person to be able to conduct electronic transaction. We can say that legal politics in several laws in the areas of technology and economy do not find necessary to mention specifically about legal capability. Now, we would like to invite all of us to find out what premises we can use to explain the political and legal phenomenon of various legislation in Indonesia. We can use the theory presented initially by Talcott Parson, but has been developed by Shidarta in his books, The Law of Reasoning and Legal Reasoning. He describes the law as a very multifaceted system composed of two controlling forces, namely the power of values and energy strength. These two forces then establish the following subsystem structure. There are technological at the lowest level, and then economic, political, legal, social, and cultural subsystems. The lowest subsystem has the most potent energy, but it contains the least values. This situation contrasts with the cultural subsystem. This values strength reflect a non-neutral field of law because the culture is, of course, very primordial, meanwhile the power of energy reflects a neutral lot of law. Laws that deeply in contact with cultures, such as marriage and inheritance laws, can be ensured that they exist in non-neutral domains. Thus, in conclusion, we would like to present a thesis that the legal politics on legal capability in Indonesian legislation is very dependent on the field of law, whether it is in a neutral or non-neutral realm. The less neutral a legal field is, the less clear our legal politics will be. On the other hand, the non-neutrality of legal fields also raises issues related to gender inequality. The less neutral a legal field is, the more gender inequality will be in content. Thank you a lot for your kind attention.